A shareholder derivative action is a lawsuit brought on behalf of a corporation by shareholders who are seeking relief for the corporation. To determine whether a shareholder's action is derivative, courts look to the nature of the harm and to who suffered it. In the 2017 case Tooley v. Donaldson, Lufkin, and Jenrette Incorporated, the Delaware Supreme Court considered whether a suit brought by shareholders against a corporation's directors was a derivative action. Donaldson, Lufkin, and Jenrette, or DLJ, was a publicly traded financial services company engaged in investment banking. Patrick Tooley and Kevin Lewis were former minority shareholders of DLJ stock. In 2000, DLJ was acquired by Credit Suisse Group. At the time, AXA Financial, or AXA, owned a controlling 71% of DLJ stock. Pursuant to a shareholder agreement between AXA and Credit Suisse, AXA agreed to exchange its DLJ stock for a mix of new stock and cash. Additionally, Credit Suisse sought to merge DLJ with a Credit Suisse subsidiary by acquiring the remaining minority shares of DLJ stock through a cash tender offer. Credit Suisse made a tender offer at $90 per share, set to expire in 20 days. However, the merger agreement allowed for two types of extensions. First, Credit Suisse could unilaterally extend the tender offer if certain conditions, such as SEC regulatory approvals, weren't met. Second, DLJ and Credit Suisse could bilaterally agree to extend acceptance of DLJ's minority shareholder stock, which would further delay the closing of the tender offer. Credit Suisse ultimately used both types of extensions to postpone the closing of the tender offer. The bilateral agreement to postpone acceptance of DLJ stock tendered by DLJ's minority shareholders resulted in a 22-day delay to closing. Subsequently, Tooley and Lewis brought a class action suit against DLJ's directors in the Delaware Court of Chancery, alleging that the directors breached their fiduciary duties to DLJ's minority shareholders by delaying the proposed merger. In response, DLJ's directors moved to dismiss the complaint for failure to state a claim, which the Chancery Court granted. In its opinion, the court concluded that because the delay affected all DLJ's shareholders equally, the plaintiff's injury wasn't a special injury and the suit was a derivative action at most. Tooley and Lewis appealed to the Delaware Supreme Court.